Exhibit 5.3 in the textbook, which is titled The Affirmative Action Realities, is a great example about how misinformation and misrepresentation of affirmative action is out there. So I'm going to talk about a couple of these here. Number one, affirmative action does not require employers to remove qualified whites and males from their jobs and give these jobs to minority and women, whether or not they're qualified. So first of all, no one is going to be removed from their job just to replace them with someone who is white, women, or a minority, even if they're highly qualified for the position. If someone's in a job and they're doing their job well, there is no basis for removing them and then replacing them with anybody in these protected classes. Number two, affirmative action does not prevent employers from hiring white males who are more qualified for the job. There are provisions in place. If you have a highly qualified white male and you want to hire them for the job, there is absolutely no reason why you cannot do that, period. Now, if you are underrepresented and you have two equal candidates, that's a very different story. And you might choose to make the diversity higher because you want to have more diverse people, but that's fundamentally where you want to go. Number three, under affirmative action, an applicant need not simply be a female or a minority to be placed in a job. So affirmative action can be affirmatively figuring out who is underrepresented in my company and how can I improve that. So it can be, you can do affirmative action to attract more males to your businesses if you're in a female dominated business and you want to be more diverse. The law takes the position that any employee who obtains a job under an affirmative action plan will be qualified for the job. So the first assumption is you have to be qualified. There are no provisions whatsoever that say you are obligated to hire somebody who is underqualified for the position. Workplace productivity and efficiency do not suffer under affirmative action plans. So oftentimes one of the arguments you'll hear is, oh, well, we will lose money, we're not going to be as productive, it's going to be lousy, whatever, and that's not true. What we see consistently is any organization that's proactively doing affirmative action, productivity and efficiency does not suffer. We believe we have always lived in a meritocracy in which the best person gets the job. That simply has not always been true, and has operated to disadvantage women and minorities. And this is absolutely true. We would love to believe it's a meritocracy, but it's a meritocracy, has been a meritocracy within white males. So the most meritorious white male has gotten the job, but that has not necessarily been the case for women and minorities. And so when they're in the pool, often they get removed from the pool or they get downgraded and evaluated as lower. I've already shown you and talked about the research that we found where we noticed that women were evaluated more poorly, based on, the same resume as a male. And fundamentally, that's evidence in and of itself that it's not always the best person who gets the job. And in fact, women and minorities tend to be downgraded or lowerly evaluated as compared to white males. It's just a statement of fact. There are workplaces where affirmative action is still needed to make sure job applicants have more of a level playing field. And that's not true in every organization and every workplace, but there are many that it's still an issue. If a female or minority is in the applicant pool with other non-minority or female candidates, the female or minority need not be automatically hired. Again, just because someone's a female, someone's a minority, it does not mean that you have to hire them simply because they're in the applicant pool. You have to hire the best person for the job regardless. And when you hire the best person for the job, it might be a female or minority, but the best person might also be a white male, in which case you are absolutely allowed to and should hire the white male for that position. Employers are to apply to females and minorities the same job requirements they apply to males and non-minorities. So we don't set up different standards for females and minorities. We don't race norm, or gender norm, hiring scores or hiring cutoff scores for hiring people. So we want to make sure that we are applying the same standards for everybody. Affirmative action is not about punishment or reparations or slavery. As noted in Congress's apology to slavery, it is about the present day impact of race and gender on minorities and women in the workplace. So it's how our attitudes about race and gender, and how, since white men have been largely in control of organizations historically, how the natural reaction that we have is to surround ourselves with people who look like us and act like us and think like us. That's really what affirmative action is trying to counterbalance. It's trying to tell us that you need to let go of that similar to me bias, which is a very common bias that we all engage in, and actually look at the characteristics and give people a chance, despite the fact that they may look different from you. Minorities and females can and should be terminated from their jobs if they do not perform as required. However, their race or gender may not be the reason for the termination. Their actions should be. So you have to document the performance of every employee, and you have to document it in a very detailed way. So when somebody makes a mistake on the job and they've been disciplined for it, then you need to make sure that you have that documented in your records, so that you've got an ongoing record of what they've done, what was the problem, and how it's supposed to get resolved. Fundamentally, if we don't do that, we're going to run into problems where we are more likely to let somebody stay on who's a poor performer, or we may not have a documented ability to be able to say, we're going to let you go because you're a poor performer. If you tell somebody that they're a good performer even when they're not, you're doing yourself a disservice on that particular situation. As I stated before, there are 3 ways in which you are obligated to do affirmative action. Actually, 2 ways which you're obligated, and 1 way you can voluntarily choose to do it. Number 1, through Executive Order 11246 that covers federal contractors, and we already talked about the thresholds that you need. You have to have 50 employees, $50,000 contract. Or judicially as a remedy for finding discrimination under Title VII. And then lastly, you can choose to voluntarily do affirmative action. You can have a voluntary affirmative action plan. That's your decision for hiring, and that works perfectly fine. The origins of Executive Order 11246 comes from World War II executive orders that desegregated the weapons industry. So it allowed for Black-owned businesses, right, to be involved in that. And we also, started to allow Blacks to serve in the military. Obviously some challenges around that. It took a while for that to be fully integrated, but now we're in a much better place around those sorts of issues. The executive branch can set the rules for contractors. That's part of the purview of the executive branch, is they can create executive orders for people who do business with the federal government and who are involved in all of the administrative agencies. And so the executive branch is the one that sets the rules for the contractors, deciding what characteristics do they want to see in their contractors to ensure that they are treating their employees fairly and they are hiring diverse people. So we don't want to be giving our money, contract money to organizations that are not, that are not treating, women and minorities, or they are actively discriminating against them. So think about it that way, right? I mean, when we boycott a company that we don't like because they're behaving in a way that we think is inconsistent with our values, this is what the federal government is saying. That discrimination is inconsistent with the values of the federal government, or it certainly it was at the time, when it was passed in the 1960s, 1965 specifically. And that if we don't like that behavior, right, as we boycott it, then we don't give them our money. We choose not to hire them. We choose not to frequent their business. And this is what the federal government is drawing their line in the sand. And they're saying, we expect our contractors to not benefit from discriminating against individuals, and we don't want to give them our money, right? Because women and minorities pay taxes. as long with white males. So our tax money is now going to pay for discrimination. So you can see how that sort of is this long, path from, someone engaging in a behavior and then making a decision, what impact that has in the long run on our women and minorities. The Office of Federal Contract Compliance Programs under the Department of Labor is responsible for enforcing Executive Order 11246. They have enforcement capabilities. They can penalize people for not engaging in provisions, et cetera, but they are the group, not the EEOC, but the OFCCP is responsible for administering executive orders because they're involved in this executive order because they're involved in the contract compliance. And so that's what Executive Order 11246 is about. It's how the contractors behave. So getting into the provisions again, just to make sure I reinforce this, all contractors and employers who contract with the government must abide by Executive Order's non-discrimination provision. It has increased compliance requirements for anybody with a contract of 10,000 or more, and subcontractors and contractors with 50 or more employees and contracts greater than $50,000 must actually develop affirmative action plans for each site. So if you are a multi-site organization with plants in different areas or buildings in different areas, you have to actively engage in an affirmative action plan that is unique for each site that you have. And that's usually you have to do that if you're not already doing it. You have to do it within 120 days of the beginning of your contract. Since 2014, the regulations have been expanded to include disabled individuals, which includes a $10,000 or more contract, and veterans, $100,000 or more contracts. So encouraging people to include disabled individuals and veterans as part of affirmative action. So the affirmative action plan that was discussed in the previous page is the tool that management uses to decide how they're going to affirmatively attract more women and minorities to their organization and affirmatively have an impact on the management development of individuals within the organization. So it is your plan, and it's the management tool we use to improve the diversity of our organization. That is under the Code of Federal Regulations, Part 60-2, and there's the link there if you want to go to it so you can read more about the specific, what the plan actually should entail. Now, the key is looking at underrepresentation and underutilization. So underrepresentation meaning we are, as compared to the viable market around us, we are underrepresented in our organization based on what is available in our local area in terms of skill set and things like that. So if we have an area where there is a high percentage, let's say there's 25 or 30% African Americans, and we only hire 1%, then we are underutilizing, or we have an underrepresented group as compared to the viable a local labor market, or whatever we consider to be our labor market. And so we have to look at what the statistics say with Bureau of Labor Statistics to be able to make that comparison. And so what that basically means is that we have fewer qualified workers, in the workplace relative to what we know are the qualifications out there. So we have to, when we are creating our plan, it has to target, or it will target whoever we consider to be, minorities and women and whatever groups are underrepresented in our organization. So part of your plan is coming up with what your profile looks like. It's the snapshot, as they call it, of what our staffing patterns look like for each unit, right? And how are they breaking down in terms of race and gender and ethnic composition? Do we have people grouped in some areas that are going nowhere? Do we have, equal representation across? Do we have are we fully represented given what our local labor market looks like? So our profile is really kind of that snapshot of what we look like today, right? Your job group analysis is where we're looking at and we're combining job titles with similar content and wage rates and opportunities. And our goal here is to ensure that jobs that are primarily women, right, or primarily have minorities in them for whatever reason, if they have similar content and wage rates, they should be paid similarly to majority groups. And so what we're looking at is looking at which jobs are similar based on the required skills to do those jobs. And we want to make sure that people are being paid the same and that we're not downgrading those jobs for any particular reason to avoid paying people properly.